Let me set the scene. A child sex offender who admitted to trying to sexually communicate with what they thought were two female children. It was in fact an undercover police operation. Is granted anonymity after threatening to self-harm if their name is released. And there's another paedophile who admitted 22 offences involving possessing, distributing and making indecent child abuse images, was again granted anonymity for life on the grounds that he could self-harm. Is that right? I don't think it is. And neither did Tanya. Tanya, thank you so much for joining me. What an incredible case those two are. Let's break them down and deal with the very first one in relation to the undercover operation.
It's actually the tip of the iceberg. This has been going on for years. And the issue there was he claimed that he had no issues psychiatrically beforehand, but when he was detected, charged or brought in for questioning and informed that you've actually been speaking to an undercover officer, his first reaction was, well, I knew that. And I just wanted to see how long it took to get caught. But within 2 weeks, he has told his lawyers, oh, well, if I'm going to, because there's a 28-day charge sheet to get him from there to his first appearance in court, I'll kill myself if I'm named. And that's literally all you have to do to get an order. Because of the delays in the system, and I'm sure it's the same everywhere else, but the PPS over here are under huge pressure at the moment, probably a throwback from COVID. But in order, they get an interim order, but because the judge is loath to, it's all based on Article 2, right to life, they by default get anonymity right to the end because it takes so long to get a psychiatric report. It's never a treating clinician. It's always one that the defence bring in for the sole purpose of deeming this person at risk. Now, that worked for a while, and just this is why we're tighter on it now, because if Article 2 is being applied by the court on press in the sense that they cannot put this man's life at risk, we were then saying, well, what about his doctors? They're equally bound by the Human Rights Act. Why are they not sectioning this individual? Bottom line is, it never reached that threshold, but they're telling us that you can't publish his name. He's at real and imminent risk. And when we see real and imminent risk, we used to go, well, nothing we can do. We now hit back and say, well, where's the evidence of what his doctor has done? Or this treating clinician who you got legal aid to form this report? I certainly wouldn't want to put anybody else through a psychiatric assessment, but that's literally what it's going to come down to, because it's between press and the court. And if the judge, go ahead.
So are you seeing that in relation to not just paedophile cases, but other criminal cases? I mean, are defendants using this as a way to stop their name coming out?
Yes, but in the majority, it's sex offenders.
Right, because of course it's the most heinous crimes, and people are, the least forgiving in relation to those crimes when they take place.
But that's the problem. If you have, I would say 95% of the challenges that I do in these instances are sex offenders. And that in itself is a problem, because it's becoming almost automatic that you seek anonymity. That if it lasts through and there are issues there, I can understand that, but I need to see that action is being taken. It's not up to us. And let's be honest, publishing isn't the problem. It's other people finding out.
Yeah.
So there's a bridge there, and we're moving around some of them, but some of the judges just terrified of the idea of an Article 2 breach. But we now, Northern Ireland has the proud total of adding a permanent anonymity to the existing 6, who included Maxine Carr, the Jamie Bulger killers. That's the level that gets lifetime anonymity. A sex offender who will reoffend, there's no doubt about it.
And why is that being granted? So I'm slightly lost to understand. So they're basically saying their initial argument is that they might kill themselves. But whilst they've then been put into custody and they're in the safety custody element of the prisons, how is there then an ongoing anonymity justification?
the majority of sex offenders over here are, depending on the crime, are released on probation for
when
3
they're
years.
non-custodial, this is relating to.
We had a few who tried to keep it on while they were in custody because they believed they were at risk. But we had a wonderful judge who absolutely threw that out the window and said, this person has the protection of custody.
Absolutely. That's the point I was making.
Really, it became a cornerstone for us to build our argument on.
Yeah. I mean, that's the point, isn't it? And the point I was making is if they're in custody, the very nature of being in custody, whether that be police or prison, is there to protect them. So this has become quite a big issue for you. I mean, in terms of the courts, are you finding that the courts are very much in favor of the defendants, or are you seeing that they are saying, hang on a minute, we're now supporting you, and that they really need to justify it?
50-50. We have some judges, and this is what's a problem. We don't have a uniform approach. Some judges won't touch it. It's just go away. They
won't touch your appeal for the rate.
No, they won't touch an application. They simply say, look, open justice. I'm not interfering with it. Okay. Now we had a slightly different one last week where it was a police officer was charged with misconduct.
Right.
Over here, no police officer faces court on their own address. And that's just part of the security measures. So he has the default address of a PSNI police station. And he actually went to a judge and said, didn't say a word to press, no advance notice. This man needs anonymity. He's under threat. Well, there's a generic threat that's existed for oodles of time here. But a deputy judge was sitting and he looked at it and he went, oh my goodness, substantial damage could be caused here if I don't make this order. So we then tried to intervene, and because everything's site link at the minute, opened the link and said, excuse me, your worship, and we were muted. So we sent an email in, the case was recalled. Neither the defence, the PPS, nor the judge knew what they were doing was wrong. And at one point, the judge actually said, I'm not sure of the procedures here. And yet he had granted an order on the back of not knowing the procedures. So out of 4 sectors with an interest, only the press knew how to do it right. And that's really quite worrying.
Oh, and why is that? Why are the court? I mean, this isn't something that's coming out fresh and new. It sounds like it's been around for a while. Why don't they know?
Well, we've tried to engage with the Chief Justice. We've offered to finance and to facilitate training. We're very, very open to discussion, but it just seems to be, let's try it. And where there is an issue about sexual offending, it's front and centre every time. And it's never that they had long-standing issues. They develop the issues. As they're arrested, a private psychiatrist gives them an assessment who refuses to come to court for any questioning down the line. And we have to fight extremely hard to get those orders lifted. And they are usually only removed at the end of the case. So they've had anonymity by default throughout the trial, which is at a different, it's not parity of esteem with any other person coming into court. So, they're breaching parity, but we cannot get it through. Some judges have come round superbly. Others, we just constantly are. I mean, I used to do one of these applications once a month. Now it's once a week. And it is extremely difficult to try and keep on top of the amount of cases that defence lawyers want kept out of press. And when you have a sympathetic judge who doesn't want to make waves, this is what happens.
And just going back to those paedophiles, so when you manage to get their name released into the public domain, is there a backlash? I mean, their argument that they are then going to, take their life or something like that. Any has that happened?
No, we've had none. If I really thought the person was totally vulnerable, I probably would think it over. It's and I also want to be very careful because there are significant mental health problems out there. And there are people who genuinely do attend court in a very poor mental state. As a matter of fact, I'd say 75% of people coming to court are not in a good mental state. But I wouldn't want anyone taking their own life. My concern is that there are others who are going to play on that because they can no longer say sex charges and perhaps the victim, there's a nexus there. Oh, well, you can't name them because, well, we can name them, but not name the nexus. And once we got over that hurdle, we started to be hit with this Article 2 every time.